Right, intellectual property law. Last na to, finally. So, explain the law of patents. What is patents? Exclusive right granted for product, process, or improvement of a product or process, new, inventive, and useful. Right gives inventor to exclude others from making, using, selling of the product. So, dapat may technical solution siya, novelty, inventive step, and industrial applicability. Technical solution is a solution to a problem in any field. Novelty, not new, if forms part of prior art. Inventive step, if it is not obvious to a person skilled in the art. Industrial applicability can be produced and used in any industry. So, ano mga not patentable discoveries, scientific theories, and math? Siyempre, patent na ba yun? Schemes, rules, and method, treatment, human, animal body by surgery or therapy. Hindi mo pwedeng pa-patent yan. Importante yan sa tao. Hindi mo pwedeng pagdamot yan sa tao. Pero yung mga products and composition ng product, patentable yan. Yung plant varieties, animal breeds, ba't hindi ba yun? Ipapatent mo pa? Ikaw ni Papa Jesus yun. So, hindi applicable yung microorganism and non-biological. Yung microorganism and non-biological, they are patentable, okay? Aesthetic creation, not patentable. Contrary to public order, malamang, not patentable. First to file rule tayo dito. Ngayon, pagka dalawa yung inventors, para sabay silang gumawa, magkatulong sila, joint sila, ha? Right of priority. Kaya ganito naman, sa ibang bansa, napatent ko na itong invention ko na to ng January 1. Mas nauna sa'yo, pinatent mo February. Mas sa ibang bansa pa. So, wala akong record sa Philippines. So, kailangan within 1 year, within 1 year from filing ko dun sa ibang bansa, makapag-file ako sa Philippines. So, within 6 months, pag-file ko, dapat nagkaroon ng English translation and certified copy of foreign. Yun. Okay pa rin yung tayo with the patent. So, by commission, who commissioned the work owns the patent unless otherwise proved in the contract. In the course of his employment, pagkat kahit ginamit pa yung mga facilities and resources of the company, and it's not part of the regular duties, employee, pero pag part of regular duties, unless agreed upon employee. So, literal infringement. May long infringement, literal infringement, and doctrine of equivalent infringement. Literal, resort to the words of claim and context of the claims and specification. Literal, yung claim, tsaka yung context of claims and specification. Doctrine of equivalent infringement appropriates prior invention by incorporating innovative concept and modifies and perform substantial function. Function means result test. Okay? Ay, nahihilo na ako. Sakit na ng kanya pa akong sasalita. Hirap pa lang may reviewer. Okay. What else? Ito lang summary nito. Pagka-patent, yung protection of right is upon registration in the intellectual property organization. Office pala, hindi organization. Okay. So, yon, and patents, life is 20 years, hindi renewable. So, after, kung pare gumawa ako ng gamot, for 20 years, yun, makapagsaya-saya ako kung lang pwede magbenta. Pero after 20 years, pwede nilang gayain. Yun nga yung mga generics. Yung trademark, service mark upon registration din sa IPO, 10 years, unlimited, renew. Yung trade name upon use, 10 years, unlimited. Copyright upon creation, and life plus 50 years after death. Okay? Next, trademark. Visible sign capable of distinguishing goods. Service mark, pag service. Trade name, name designation. Collective mark, origin. So, ano din yung infringement sa trademark? Dominancy test and holistic test. Pagka holistic test, yung mga marks and labels and packaging focuses not only on predominant words, but other features and labels. So, dominancy test naman, similarly siya sa main and prevalent essential features, cause confusion, and imitation is not important. Basta kapag important is to deceive purchase, may intention siya ganun. Dominancy test. Again, dominancy test, essential features, imitation is not important. What is important is it deceives purchaser. Holistic test naman, marks and labels and packaging, yung pang, yung ginaya, ganun. Ayun, so, trademark infringement versus unfair competition. Yung trademark infringement, use without consent, reproduce, counterfeit, or copy, or colorable imitation. Validity of plaintiff marks, plaintiff ownership, use of mark, its colorable imitation. Yung unfair competition naman, passing to the public goods to deceive the public, confusing similar general appearance, deceive public fraud. Ayun. So, unfair competition, proof of fraud is kailangan intention to deceive and actual or probable to recover. So, yung copyright, original work, literacy, scientific and artistic domain, writings, musical works, films, paintings, and computer programs, copyright. May dalawang right, owner, economic right and moral right. Economic right, remuneration and exploitation. Moral right, personal connection, attribution, alteration, integrity, and restraint the name. So, yung commission of works, who commission owns, pero yung copyright, yung gumawa, the creator, unless there's a written agreement ang kailangan. So, yun, intellectual property. No. Okay, tapos na. Finally.